Madam Speaker, I rise to lead the debate of and have read for a second time in this Honourable House the bill shortly entitled Plea Negotiations and Agreements Bill 2024. This bill represents an important step in the strengthening of our criminal justice system by introducing a structured plea negotiation framework. It is designed to address inefficiencies in our legal system, reduce delays in the administration of justice, and provide a clear process for plea agreements in serious criminal cases. Our criminal courts are overwhelmed with cases, causing significant delays and resource constraints. I'll give you an example. Just last assizes, one case started in September and ended in December. So in the last assizes, I believe the court was only able to conclude 3 trials in the entire assizes. So there is a backlog, and the backlog hinders the timely resolution of matters and in many instances prevents justice from being served efficiently. The Caribbean Court of Justice Academy for Law hosted a criminal justice reform conference in October 2023, which I attended and made a presentation, but more importantly, which led to the Needham's Point Declaration on Criminal Justice Reform. Since its publishing, the declaration has been cited in many cases throughout the region as a benchmark for criminal justice reform. The declaration identified plea bargaining as a crucial tool in addressing case backlogs and expediting the justice process. In Legislative Intervention 10 of the declaration, it states that the laws are to be enacted to provide for maximum sentencing indications as well as effective early guilty plea bargaining schemes. And in the judicial intervention, number 34 in the declaration, that courts should adopt a focused and integrated approach to eliminate criminal case backlogs by using tools and measures such as robust case management coupled with plea bargaining discussions. The European Union-funded PACE Justice Project, of which St. Kitts and Nevis is proud to be a beneficiary, has also committed to training the Director of Public Prosecution's Office Crown Prosecutors, of which you used to be one, Madam Speaker, and relevant stakeholders in plea negotiations, reinforcing the necessity of this bill. Plea negotiations, Madam Speaker, and for the general public to understand, are a well-established practice in legal systems worldwide, providing numerous advantages. 1, efficiency. Cases can be resolved more quickly, freeing up judicial resources for complex trials. 2, resource management. Both the prosecution and defense benefit from saving time and costs. 3, certainty. The process provides clearer and more predictable outcomes for all parties. And 4, victim participation. Victims have an opportunity to contribute to the process through victim impact statements, ensuring their voices are heard in sentencing decisions. Plea bargaining, Madam Speaker, is in essence, if someone is charged with an offense and they are likely to plead guilty, if the offense had a maximum, let's use the causing death by dangerous driving, which is now 10 years max. The person said, listen, I am willing to plead guilty. And they go to the prosecution says, what do you think, if I plead guilty, what sentence do you think I would get? The prosecution can say, well, this was a case of careless driving, causing death by careless driving, for example. So we think you are likely to get 3 years. Then, without having to go to a sentencing hearing or going through trial, the person can accept the 3-year sentence. It is then taken to the court for approval, and there is no trial and no further action. The matter is resolved, the punishment is set in stone, the person serves their time, and there's no resources used in the trial and sentencing of that matter. That is effectively how a plea bargain works. And it has been proven to be an essential tool in various jurisdictions. The highest example of plea bargaining is in the US, Over 94% of criminal cases at the state level in the US and 97% of cases at the federal level are resolved through plea bargaining. It has significantly reduced the burden on the courts, allowing them to focus on the more serious cases that require full trials. I know many persons in St. Kitts and Nevis watch these crime shows, Law and Order and NCI and so forth, and you always hear about them having a discussion and saying, accused having a discussion with a lawyer saying, should I take the plea? Should I take what they're offering? So if, for example, you do a crime, maybe an armed robbery, and the maximum is 20 years, and the prosecution is saying, if you plead guilty, we'll offer you 8 years. And then the person has to make that tough decision whether to plead guilty, take the 7 years, or take the chance with court, which is going to take a year, 2 years, and potentially get 20 years. So this is a practice in the US which we have decided as collectively as a region, we don't want to go to that extreme because plea bargaining in the States is almost the first resort. But we want to use it to eliminate some of the matters in court and speed up some of the matters through the court, and it's fair to all sides. For example, in Canada, plea bargaining helps streamline criminal proceedings and is governed by strict guidelines, similar to what we propose here, to ensure fairness and transparency. It's also used in the United Kingdom. The Sentencing Council provides structured frameworks for sentencing reductions based on early guilty pleas, incentivizing cooperation while maintaining judicial oversight. In essence, Madam Speaker, it costs money to run a criminal justice system. There are officers, there are prison officers, there's judges, there's clerks, there's registrars. It takes a lot. You have to get a jury impaneled. You have to feed everyone. It's very expensive in all over the world. So plea bargaining has been used as a way to expedite certain matters, take them out of the system, and have fairness for all sides, including the victim and the accused. Trinidad and Tobago has implemented it. Jamaica has implemented it with success. So people might ask how it speeds up the system. The ability to expedite cases is one of the primary benefits of plea bargaining. Criminal trials, particularly for serious offenses, require significant time, resources, from pretrial motions to examination of evidence and witness testimonies. Sometimes in these complex cases, the deposition is bundles of documents this big. And sometimes they're boxes with all the evidence, DNA, video, statements from different witnesses. It gets complex. So what the plea bargaining system that we're proposing by this bill does is it reduces the case backlogs. It diverts some cases from full trial so that the court can focus on more pressing and complex cases. Then there's also faster resolution for victims, because sometimes victims have to suffer through years of prosecution of a matter when the matter can be resolved fairly quickly. It's also more efficient use of resources. Prosecutors, judges, law enforcement officials can allocate their time to high-priority cases rather than spending months of trials that could be resolved through negotiations. I'll give you an example. That trial that took from September to December, the accused had an opportunity to plead guilty, and I think would have gotten time served because it was an arson offense. And I think the arson, the maximum sentence for arson is fairly low, and the person had served some time. But the person decided to keep the matter going, and it took up 3 months of judicial time. And I think the person is to be sentenced still. But that is a factor to be taken into consideration by the court, how much of the resources of the court have been taken up by this case. And that person could have what we call pled out and be released by getting time served. So this provides an organized framework for those sorts of pleas to be done. It also encourages cooperation between the defendants and the prosecutors, and it saves the state lots of money. It also complements the other criminal justice reforms that we have implemented. For example, the judge-alone trials, the voluntary bill of indictment, because the matter then proceeds to the judge much quicker, and the justice interference, because one of the issues is when you have trials running for years, you have potential of interference. The longer the time, the more potential of interference with witnesses, jurors, etc. So you get the matters out of the system and you protect the justice system from external and bad actors. What the bill does, Madam Speaker, it applies only to indictable offenses. So those are matters in the High Court, or we call it in saying it's upstairs, before the judge and jury, ensuring that only serious matters are subject to plea negotiations. The DPP has the sole discretion in initiating and conducting plea negotiations. So if the DPP does not feel that this is a case that should go to a plea, that they should be fighting to get the maximum sentence for a particular offense, they can say, I'm not interested in any negotiations. The defendants must be informed of their rights, including the right to legal representation and protection against self-discrimination. So in other words, somebody's not going to be forced into a plea without them having the opportunity to get legal advice. They can occur at any stage of the conviction, including before formal charges are laid. So for example, if you're caught red-handed in an armed robbery in a supermarket and the police hold you, you can say, I'm caught red-handed, I would like to have a discussion with the DPP for me to plea out. So even before the charges are laid, because they know they're going to be charged with armed robbery and so forth. So it can happen at any time. The agreements must be in writing, signed by the DPP, the accused, and their attorney. So it cannot be a situation where the person is signing it, not knowing what they're signing. They have an opportunity. The lawyer signs it, they sign it, the DPP signs it. That's what bakes it. The court must review and approve all plea agreements within 28 days to ensure fairness and justice. So there's a third-party review from the court to determine if it's fair. So the DPP, for example, cannot go on a frolic of his own and give a 2-year plea for a 30-year sentence. The judge simply might not accept it, and the matter will have to go to trial. The victims have a right to provide impact statements before the plea agreement, because at the end of the day, a lot of crimes, there is a victim, and the victim has an opportunity to have their say. If they feel that this is a matter they want that they're in court, they want the person to be potentially get the full sentence, they can then say, listen, this has an impact on my life. I then want this matter to proceed and go to the full extent of the law. Either the prosecution or the accused can appeal if a plea agreement is rejected by the court. So if you feel that the court is unfair in rejecting a plea agreement, you can challenge it. There are provisions for convicted persons to assist law enforcement in exchange for sentence reductions. Now I want to explain that. If somebody has been convicted and they have evidence on somebody else, the DPP's office can negotiate with that person to reduce their sentence in exchange for helping to prosecute someone else. So for example, if somebody is caught on a possession offense, and then there's somebody, they have evidence to get somebody on a murder offense, that person could have been convicted on the possession and get 10 years, for example, 15 years, and negotiate with the DPP, say, if you take off 5 years, I'll give you all the evidence on the guy that murdered this person. And that the legislation allows that to happen. And also there's strict confidentiality rules apply to protect the integrity of the negotiation process. So there's a declaration of existing rights in Section 4, where accused persons retain the right to plead guilty without entering into plea negotiations or plea agreement. There is the Section 5, which deals with the actual plea negotiations and when they can occur. There is a Section 6, which says there are no obligations on the state to enter into plea negotiations. Section 7 sets out the powers of the DPP to withdraw or discontinue the original charge or accept a plea to a lesser offense. I want to explain that. If you are charged with murder, in the situation that was given in the wrap-up by the member for number 8, you push someone, they fall down, they hit their head, they die. And you are charged with murder, meaning that the police believe you had the intent to kill. And you wish to plea for manslaughter, saying, listen, I did not have the intention to kill, but I caused the death. Then the DPP could accept a plea of the lesser charge of manslaughter rather than proceed to trial on the murder charge. So it allows for that sort of negotiation. Section 8 deals with the legal representation, as I spoke about. Sections 9 to 11 deal with the details of the plea agreements, who must sign them, where they must be filed, the forms which are in the bill, etc. And Section 12 deals with when the matters are to be listed for plea agreement hearing. That is when the judge determines if the judge is going to accept the plea agreement or not. Section 13 deals with plea agreements at committal proceedings. So if a plea agreement is filed before an accused is committed to stand trial, the magistrate must cease the committal proceedings, transfer the matter to the High Court, and forward all relevant case documents within 14 days. And the magistrate can grant bail during that period. Section 14 deals with the DPP to prefer indictments. The 15 to 17 speaks about the victim impact statements. That is where the victim speaks about how they feel about what happened, and then there's a determination as to whether this matter is one that deserves a plea. Section 80 deals with notifications of the plea agreement. The DPP must inform the court of the plea agreement before the accused pleads or at any time after arraignment. Section 19 deals with the procedure at the plea agreement hearing. Sections 20 to 21 deal with the court's authority over plea agreements. And the court, and I think this is important, the court may reject a plea agreement if it is not in the interest of justice. If rejected, the court must inform the accused of their right to a trial before another judge. And the rejection does not prevent further plea negotiations. Sections 22 to 23 deal with appeals of plea agreement rejections. 24 to 26 deal with the effects of accepting a plea agreement. 27 to 28 deal with post-sentencing negotiations and sentence reviews. Convicted persons may enter into a post-sentence negotiation for sentence reduction in exchange for assistance to the state. I want people to understand that. If there are persons who have been convicted already and they can assist the state in getting who they really wanted in the first place, this provides that opportunity and structure for that to be done. Section 29 deals with the power to reduce sentences for assistance of the state. 30 is withdrawal of the plea agreements, which you can do. An accused may withdraw, they might have a second thought, and they withdraw the agreement before it even goes to the judge. Then 31 deals with setting aside the plea agreement, where the DPP may apply to the Court of Appeal to set aside the plea agreement if it was obtained through deception, coercion, or other unjust means. And then 32 to 34 deal with admissibility and confidentiality, and then Section 35 gives the power to the minister to issue regulations and so forth. So the bill, Madam Speaker, is a comprehensive framework for plea negotiations, ensuring efficiency, fairness, and procedural safeguards in the criminal justice system. It's a necessary, modern, forward-thinking reform to our legal system. It strikes the balance between efficiency and justice. It ensures that cases are resolved in a timely manner while protecting the rights of all involved. And by modernizing our approach to the criminal justice system, we can ensure that justice is both swift and fair. Neither are compromised. And I encourage my colleagues in this honorable House to support the Plea Negotiations and Agreements Bill 2024 so that we may advance towards a more effective and just legal system for the people of St. Kitts and Nevis. May it please you, Madam Speaker, I so move for this bill to be adopted by this honorable House. May it please you.